All right. We're going to move on. Last matter on calendar happens to be page 6, Orion, Gallagher versus Affinity Lifestyles. No, I understand. Yeah, we're a little early, but it doesn't happen that way all the time. Hopefully everybody's checked in. We'll find out, though, right?
Good morning, Your Honor.
Yeah. Let's go ahead and good morning to everybody. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Your Honor, Kemp for plaintiffs. David Spurlock.
Your Honor. I'm sorry, go right ahead.
Sir, go ahead for the plaintiffs.
I think the plaintiffs.
Well, we have a couple other. We have people on the phone.
Okay, all right.
Your Honor,
let's go ahead.
Good morning,
as far as the plaintiffs are concerned. Yes, go ahead.
Yes, good morning, Your Honor. This is Teddy Parker on behalf of plaintiff Richard Haley.
Anyone else on behalf of plaintiff? Doesn't appear to be. All right. Let's continue on with the defense.
Good morning, Your Honor. David Spurlock, United Natural Foods West.
Morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments.
Good morning, Your Honor. Joel Odou on behalf of the real water entities.
Good morning. Anyone else?
Morning, Your Honor. Jim Kavanaugh with Gordon Reese in Las Vegas, on behalf of third-party defendant, Real Water, Tennessee, LLC.
Good morning, sir. All right. Yeah, I guess we have to continue with appearances, right?
Yep.
Okay.
I believe that was all of them.
Is that all appearances for the record?
Oh, no, Your Honor. There's lots more.
Right. Okay, that's all that's checked in.
Yeah.
I'm wondering, do you think we should wait until 9:30?
Usually, Your Honor, we do these depositions, we have 20 to 25 people.
I agree. I don't know why there isn't that many, but I think with what we're dealing with today, what I suspect will happen, I'm not sure that we need to wait that much.
Okay. Well, I mean, I don't mind telling you this. There's a lot to discuss here. I'm actually kind of glad you happened to come in fortuitously because I don't mind telling you this. I have to do some planning for my fall trial calendar and scheduling, and we'll talk about that.
Okay.
Also, I know there's issues regarding jury questionnaire, and here's a big issue in this case. I'm always concerned about time qualification. Of course, that's a basis in and of itself for a questionnaire, because how many weeks are we talking about trying this case?
Asia.
Judge, I've got our case in chief down to 12 days now, and I'm trying to whittle another one down, but that does not include jury selection.
I understand.
Or opening statements. Right.
And it always takes longer.
Yeah, I mean, I appreciate plaintiffs' positivity and what they think. The reality is I think the cross-examination will take significantly larger amount of time than maybe perhaps is anticipated.
Yeah. And I look at it from this perspective, in a general sense, it would be best guess. And because that's one of the issues we do have to make sure we disclose to the panel when it comes to time qualification issues, right? That's a big deal. It really is. And I do understand that we all want to be efficient, but I'm in trial right now in a water rights case. And when was that supposed to finish up? Last Friday. And I don't know if it'll finish up next Friday. And that's just the character nature of what we do.
It may just go 6, but I think the cross-examinations will take a while. I think there's some other issues amongst the defendants who will be cross-examining each other.
I understand. I get it. And I mean, and I want to make sure, and see, here's my point. I'm not trying to put pressure on anyone from shorten the case up right now, because we're not in trial and where I can say, look, gentlemen, I think you should be a little bit more efficient with our time. No, we're not there. I'm just wanting to make sure we have a range.
Understood. Worst
case scenario potentially, because you do have to inform the panel on a big issue in this case. And I thought actually the jury trial could go much longer than that. We'll talk about that. But just have to let the jury know about that. Then there's another question as to how many panel members we bring in to fill out the jury questionnaire. And sometimes, that can be challenging too, because what we do, which is a little bit different, and my JA's not here, but we actually have them come into Department 16, fill them out here. and then we make them available for you to come copy and stuff like that. So they kind of come in waves, and it's just a little
Your
easier.
Honor, I can kind of work on that jury questionnaire. Mr. Kemp and I spoke before the hearing, and Will, if I'm saying something wrong, please inform the court as such. But we think it's probably going to be required because there's some opposition to the one that was submitted by the plaintiff that we get it, even if the court knows and orders it. I'm fine with that. That we have a meet and confer.
I'm not, and here's the thing: I'm not going to decide the final jury questionnaire today. I'm not. It's way too early.
Yeah.
But I'm going to tell everyone I'm going to permit one. So that's a good way to look at it. And if you can't work it out, it's like I do in all cases. Everyone's here has been in front of me on larger trials, right?
Yes.
I'll bring you in, and we'll go through it line by line, and if there's objections, then I rule on it.
Let us get our first shot and see if we can
Absolutely
score that down a bit, and I think that'll be what we need to do. If you want to set a date for us to do that, or if we can come up with
no,
a
I'm going to
date.
set a date, because if I don't set a date, it won't get done.
All right.
Judge, I would suggest, and we've been trying to work it out. I mean,
I understand.
The defendants were down to 9 objectionable questions. And there's some we're not going to agree to.
Right.
Because, for example, we have questions we want to gauge the jury whether they would give specific amounts, and we know the
Right.
court's ruled on that before.
Yeah, they have.
And so we're not going to give up the fight on that, and that's not going to be resolved. The court's going to have to resolve it again. But I do think Mr. Rasmussen's right. We should be ordered to do a formal meeting confer sometime in the near future. They come back here maybe in 2 weeks, and we'll give you the status and the questions that are still outstanding. And I'm thinking, generally, most people have agreed. I think almost all have agreed that we should do some kind of questionnaire. It's just a matter of the questions.
Right. Well, and I tend to look at it this way when it comes to jury questionnaires. And I remember early on, the argument was, "Well, it'll save more time." It never saves more time, as far as trial is concerned. But it's very important from a time qualification perspective, because that makes my job a lot easier when it comes to voir dire. If I know a panel coming in can commit to 5 weeks, right? Whereas, I mean, for example, with this case right now, in order to do a 3-week trial, we had to bring in 150, 160. Was it more than that, right? Yeah, because it was time qualification issues. Just going from 2 weeks to 3 weeks is a big deal.
Great.
And so that's kind of how I look at it. I mean, I don't know how many we're bringing. We might bring in, I think the request was 300, right? Initially?
At least 300.
Yeah, it'll be more in all probability. I remember we had one of our CD cases.
Yes.
And I had to basically declare mistrial, although I didn't call it that, but that's what it ultimately was from a technical perspective. But bottom line is, we had to bring in a new panel. We had questionnaires, and everybody was wondering what were we going to do, right? And I had another 500 in my back pocket ready to go just in case, right?
I think that was Mr. Parker's adventure. Right?
Yeah, that was Mr. Parker's case, But I have to plan, just like you do, and that was such an important case because we had to get the first subclass tried, right? And I get it.
I suggest 500.
500 would be fine with me, Your Honor.
Okay, and so for now we'll look at that number, approximately 500. The next issue is this, and I don't mind telling everyone this. I mean, so as far as the jury questionnaire, I'm granting that. I know there's a motion, but there's no need to have an argument on that. As far as deciding what the questions and the propriety and whether they're proper or not, of course we'll have argument on that. Okay. But in a general sense, this is what we'll do. I'm granting the jury questionnaire request. Secondly, I'll give you how much time? 2 weeks. The meeting confirmed 3.
2 weeks sounds about right.
And how about this? We set a status check on that issue in 2 weeks.
That's fine.
It's fine, Your Honor.
All right. I'm just kind of moving.
Nope,
so
I'm
that's
good with
taken off the table, right?
Yep.
Now here's the next motion we have. And understand this. I truly believe in ADR, mediation, settlement conferences, and things like that. But from a historical perspective, I don't mind telling everyone this. I don't think it works unless you have willing and able parties at every table. This is where they want to go. Because I don't want to waste anybody's time, right? And maybe down the road there might be an appropriate time, but I read Mr. Kemp's opposition and he said, I don't want to go, basically. and I don't mind telling you this. It doesn't matter who doesn't want to go. I don't think I've ever ordered a settlement conference where everybody wasn't ready, willing, and able. And for example, that's one of the things in business court cases you're supposed to talk about early on, but I just don't order them unless ready, willing, and able, And plus, you got to have demands out and some prior negotiations and those types of things. We all know, right?
Understood.
Understood, Your Honor.
Yeah.
I agree. Yeah, as Your Honor, I kind of view this as I did the hepatitis cases.
Right.
We had to try a couple of those before the settlement conference was meaningful. And I think this, we at least have to try the first one before a settlement conference will be meaningful. And I've suggested to defense counsel that after the first trial is over, I would probably be receptive to some sort of settlement conference. But I just think there's too many issues in dispute right now that cause too wide of a variance in the settlement valuation of the case. Not just among my mind, but among the judge's mind, defense attorney's mind. And so for that reason, we don't think it'd be productive.
Yeah, I mean, and I get that. I understand that. I can't disagree or agree. But the bottom line is, and the bottom line in it, not everyone wants to go. Right? So I'm not going to order it.
You need an order on that?
Yeah, you can get an order on that. However, I'm open if everybody wants to stipulate to one, of course.
Understood.
I'll do that. Another issue, and this is a real big issue because understand this, we actually do planning, believe it or not. We kind of do, looking into the future, right? And this case is currently set on the August stack, right?
July 31st.
Oh, July 3rd. And that's why I call it August, I guess. But we have a firm trial setting on a case that's older than this one. Yeah, it's the Ramirez case.
And they've done a little research on the Ramirez case because I've been told that there's a 5-year problem on that case.
There is, yeah.
Well, not really. Here's what I found. The Ramirez case was filed on June 4th, 2019. I have a copy of the original complaint here. It was served on July 9th, 2019. So the 5-year, this case is, by my calculation, 3 years, 10 months, and 14 days old as of today.
Right.
So there's not a 5-year rule problem on this case. And I haven't even thrown in the 180 days for COVID on this. But
yeah.
But
what it is there's a preferential trial setting regarding the Ramirez case pursuant to the rule, and that's another issue there.
Well, Judge, I'd ask that this case be put behind our case for this reason. This case, and I haven't had a chance to talk to the Bighorn people yet, but I would point out the Bighorn people are part of the consortium, the Real Water Consortium. Danielle Miller's on all the calls, so I would think they would.
Here's the bottom line on that, Mr. Kemp. And they've been given a preferential trial setting. And what date is that, Julian? Theirs is set for?
Theirs is set for August 19th, I believe.
August 21st.
August 21st.
Something like that. And here's my point. If they wanted to change their setting or whatever, they stipulate, I can honor that. But as far as this case is concerned, and I just want to let you know currently what we were planning on, and as far as the date for this one, Real Water would be yeah, and here's another factor too, and everyone in here has been involved in extended trials, and we know the impact, for example, the first week of school has on selecting. Yeah, we've been around, and the end of summer break and all those things, right? And so this is our thought. This was my thought process as far as that's concerned. Would be given this. It actually gives you a little bit more time, but I'd give this case a preferential trial setting. I think starting September 5th. September 5th, and you got the rest of the year.
Well, Judge, that sounds inviting, but I'll tell you what here's my concern. I'll just lay it on the table.
Yeah, just tell me.
The Ramirez case, the defense attorney is the same attorney that's the attorney for Hanna in this case.
Right.
And Milwaukee, I'm sorry. And we've been hearing chatter for the last 3 weeks that the defense bar is going to use some sort of 5-year rule problem with the case forms. And this is what's happening. Okay,
and what do you mean by that, Mr. Kemp? I want to make sure I understand.
We've been hearing in our discussions with defense attorneys, they're going, the July 31st date isn't real. We're going to get a bump by a 5-year rule case. Now here we are, in this case, again, bumped by 5 years in the case. So,
But see, really, I'm not going to be bumping it though. And here's my point: it would be, unless there's some grave inconvenience or something like that, you would have the whole fall.
okay. Would you consider qualifying the jury and having them come back?
What do you mean? Time
Pick
qualifying?
the jury. Pick the jury. We'll start out. We'll pick the jury. You can do the Ramirez case. We'll just get off to a good start.
I hear your point. I'm not disagreeing, but I want to say the following. We did that. The problem that we have is that we could lose jurors in that interim of that 1 month spot. And you worry about them going out and reading things. The media has been involved in this case. I worry about those things. I'm just going to say that. I understand. I'm not saying that it's the wrong choice. I'm just saying that maybe we shouldn't do that because it could lead to other problems in a mistrial opportunity.
I don't mind telling everyone what my thoughts are, and I do understand the importance of having certain cases tried, especially when you're dealing with mass tort type events, right? And here's my point, and this is this one said. I mean, my thought was coming in today would be, look, this case is going to get tried. You get a preferential trial setting of September 5th. Whether we start on that exact date or not doesn't matter. Because I don't mind telling everybody, I was just going to open up my entire calendar because I'm not as optimistic as everyone is here. I was thinking when I came in today that we might be trying this case in up to Thanksgiving and or maybe to Christmas. And so I realized that this case has a preferential. And so all I'm doing is just juggling. So my point is this: it doesn't matter whether Ramirez takes a week or two. It doesn't matter because once that case is done, this case starts.
Okay.
Your Honor, if I may,
Well, how about picking the jury then before Ramirez and just taking the Ramirez break and then start the case?
But why does that really matter? Because what we do, we pick. I mean, they'd be time qualified.
Well, the way it helps me, Your Honor, is I have 9 experts.
Right.
Only one of whom, one's in the punitive phase. So I really have 8 experts for the compensatory phase. And out of those 8 experts, 3 are what I call quickie experts. They're just going to come into a quickie little thing for an hour and a half. So I really have 5 serious experts. Okay. I've already got them scheduled for the August time period that I thought we were going to.
Okay, I understand.
Now I've got to go back and reschedule them for September. So if I knew that we had the jury picked and we were going to do the opening statement on September 5th or 6th or whatever it is, then I could say, okay, Dr. X, my first expert witness, you were going to go on this day, come hell or high water, and I can have him juggle his family vacations a little bit or hers. That's why it's important. It allows the case to run better because it gives us better flow on the experts. And we don't. There's not going to be a time where I come to the court and say, Judge, we got to be down this afternoon because I don't got an expert available.
And is any idea how long this case is set for?
Your Honor, if I may, with regard to the expert situation in this case, as counsel has pointed out, the experts he has, we presently have 18 experts. In addition to that, on the Department 27, we have a trial scheduled on August 7th, and Department 31st, we have a trial scheduled for October 16th. So even though we may have the autumn, we're going to run together with the trial that we have prior to that and the trial that's coming immediately after that.
August 7th?
No.
Look, scheduling of experts and all that, it's going to take some time. If the court needs us to move to September 5th, we just have to figure it out, and we'll just do it.
I just think we're better off just rolling for a week.
And I don't want to overlook anyone on the telephone. On the audio video. And I think that was Mr. Odou. I think I recognize your voice.
Just really briefly, Joel Odou for Real Water. I think the other thing for the court's consideration, I think the September 5th date would likely work, is we expect a lot of motions in limine in this case. And so I think that should be factored into our schedule. And I think the September 5th date would do that. And obviously, if we need to adjust the September 5th date because of expert availability, we understand the court will do that.
So here's my next question. Before making a final determination today, do you think maybe we should come back in a week
I'm all for that, Your Honor, because that gives me an opportunity to talk to the attorneys.
Absolutely, Mr. Kemp, because my point is
to be
this.
honest, I don't think the attorneys for the Ramirez case are going to stipulate, because one of the defense attorney for the Ramirez case is a defense attorney in this case.
Right.
So I have a
Well, they might be
suspicion.
back to back.
Well, you know, but I will talk to Danielle Miller and a bit more for them and see what their position is.
All
And
right.
maybe this is a 3-day thing. I don't know that much about the Ramirez case. Maybe it's a quicker case than
It is it's scheduled for 5, but it's a PI case.
We're currently scheduled, as I understand it right now, that we'll be here in 2 weeks to follow up on the jury questionnaire. We might be able to give you the time. Will give us the time to talk about the jury questionnaire. How about in 2 weeks, Will?
2 weeks is fine. Just as
2 weeks
long
is
as
Yeah.
someone's not going to stand up in 2 weeks and say, "Oh, I can't do July 31st now."
Right. Well, here's my
July
point.
31st stays on calendar, but
It's
we're
on
gonna be
calendar.
moving it, and
I haven't moved anything as of yet.
Okay,
All we're talking about right now is a planning session.
agreed.
Nothing more, nothing less. I haven't made any firm decisions or any of those things. And bottom line is this: this case has to, like many cases, we have to at some point have finality,
Agreed.
right?
And by the way, I agree with Mr. Odou, Your Honor. There are going to be a lot of motions eliminated.
I know, because I think everyone knows this. This is my first rodeo as far as these types of cases, and that's why I was bringing this issue up in May, not in July or August, by coming in at the calendar call. Oh, hey guys, what? No, I'm trying to get out well in advance of it, so you can plan, and maybe we have common ground. Because I know I don't know how many motions in limine are going to be in this case. I remember I had one case, I can't remember, it might have been the Williams case, and I was talking to Robert Adams. Well, after that, I said, how long did we spend in pretrial motions? He said 2.5 months. I don't believe that. I don't remember that. Here's my point. You know how they say the human condition is when it comes to bad events, you don't like to remember. But it was what? Mr. Kemp, how long was it?
I thought we got those knocked out in 3 days of elimination.
No, not in
Different
I mean,
case.
they continued. Oh, the trial?
No, I'm talking about the pretrial motions.
Oh, I thought we got it knocked out in 3.5 days. Your Honor.
Did you?
Yeah,
Okay.
but, I mean, we were coming back and, we were working around your motion calendar.
I don't have much memory of it.
I just want to make sure the court has enough time to seriously have an opportunity to review and not be hurried in their decision.
Oh, I like that too. No question.
And
But-
I'm just guessing there's going to be over 200 motions. So we're just throwing that on the table.
You think 200?
I think over 200.
Over 200? Yeah, and we're even thinking about how, and you know, we try to stay ahead. We're actually been kind of planning, and for example, maybe the motion in limine hearing should start on July 24th.
Okay.
How's that?
I'm fine with that, Your Honor.
Is everybody kind of, because we're kind of trying to plan down the road a little bit.
That'll be for dispositive motions as well.
I guess.
No,
Yeah.
I'm just asking.
Yeah, I mean, right. Yeah. We can talk about that in 2 weeks.
Let's do that.
Yeah, we can have maybe, and those are the planning issues we should be discussing right now as we get ready for trial.
All right. There's some other motions I think on today.
I think that's it, Your Honor.
Is that can you prepare orders for me on the issues we just raised?
Right. So I'm going to draft an order denying the motion for a settlement conference
Without prejudice.
without prejudice,
Yes.
and then I will be.
And we're granting the request for a jury questionnaire. There's going to be a meet and confer on that issue, and we can talk about that in more detail when you come back in 2 weeks.
Now, what I think we were proposing, I want to make sure that we're okay with this, is that the parties will get together sometime between
Oh, absolutely.
here and 2 weeks to try to iron out a lot of this and make some changes. We'll submit to the court any changes that have been made so that you have the most up-to-date jury questionnaire to be reviewed. And then I think we'll probably still have some disagreements on things, and that's okay. Then you will go through the stuff that we have not agreed on, and I'll put that in some sort of an order for you.
Absolutely. Mr. Kemp, any objection to that?
No, Your Honor.
All right.
Your Honor, Joel Odou for Real Water. I have a logistical question for the court.
Yes, sir.
I think I know the answer, but I just want to make sure it's clear for everybody who may not know the answer. I am assuming that the court, when the panel comes in to fill out the questionnaire, will be given an admonition about not to look at things on the media and so forth. And does the court want that in the questionnaire, or is the court just going to give that admonition?
I should have the questionnaire.
Yeah, put it in the questionnaire.
Okay, thank you, Your Honor.
Yeah,
We'll add that.
add that. Yeah,
And then you can say,
absolutely.
I mean, your courtroom. I don't want
Oh, yeah. We'll take care of it.
to. 2 weeks, Tori. I guess is.
So 2 weeks from today would be June 7th at 9 a.m.
I think we have a deposition that day.
Yeah, deposition here.
What?
Need something else?
No, we'll just have to work around it.
Okay.
That's the last day deposition.
I think go through the 9th. Will.
Okay, yeah, you're right.
And realistically, how many? This is one of the things you have to do for me. How many trial days are we talking about? Because
Your half days or full days?
I can just tell you this. Typically, what we do, we have full days on Mondays and Fridays, and typically Tuesdays, Wednesdays, and Thursdays we start about 10:30.
So I still think my original calculation of somewhere between 6 to 8 weeks is probably about right.
Yeah, Judge, I think, like I already said, I've got it down to 12 trial days now. I'm trying to get it down to 10. And personally, any defendant who's going to double my time is just ensuring I get a huge verdict because the jury's going to be so pissed off at them. But,
I appreciate the consultation.
Just a little advice there.
Thank you.
So I think if I go 10 to 12, I think you should count on them going maybe just slightly less than that.
Yes, thanks.
Yeah, the only real concern I have on that issue, I just want to make sure we're somewhat accurate as far as the jury questionnaire, because that's going to be a time qualification issue.
We'll probably put that in that first paragraph, so we just got it taken care of right there.
Right.
Or after the admonition not to look at anything on television and stuff.
Judge, I put all the time qualifications in the first 2 pages now because I found over the years that
Absolutely.
we used to put it in the back, right? And then we had so many problems. And I think in one of the endo cases, we actually started putting it in the front. And
Your Honor,
now it's pretty much always in the front.
Yes.
I'll let you know that this afternoon we are meeting with Floyd Hale, the special master, on some things. We'll try to schedule at that time our meet and confer within a week. And Floyd will. I don't think we need Floyd to be involved in that. That's not what I'm
You
saying.
can have it involved if you want. You can, cut some of the hay down.
If you need, it's up to you.
But we're meeting with him, so we're working out the final discovery. Discovery cutoff right now is June 9th.
Right.
I think we may have some things that go over, and I think instead of you having to deal with some of these things that may come up after.
And I don't mind telling everyone this, like when it comes to, discovery cutoffs, let's face it, the trial court's given discretion as to move that or not. But from a historical perspective, I look at discovery cutoffs, it's almost like, I remember I'd go to federal court from time to time, and I guess it was thought that, the magistrates were tough to deal with over there. And that wasn't always my experience, because I had a couple cases in federal court, and one was a union case. I don't even know how I got involved in that case. But bottom line is this, and it was really this simple. The rules, you're required to set forth everything you've done, right? And I had maybe 12 depositions, requests for production documents. I'd done a lot of discovery. But I did 2 or 3 things came up at the end. And the attitude of the magistrate was simply this: okay, Mr. Williams, I've seen you've done a good job. What do you need? And I think that's often overlooked because, past performance, and if you've been conducting discovery and you just need a couple little things at the very end, remember the rule is not self-executing, right? It's not. The court has discretion. And I always exercise my discretion very tempered as to whether or not you've been dilatory in your entire discovery case or things just come up that you need. So that's kind of...
I would say this. We have depositions scheduled all the way to June 9th. We're down to basically just the expert depositions that are left. We've done all of the plaintiffs' depositions, some of the treating physicians, all of the parties' depositions as far as the defendants. We've done all of the written discovery in this case, as far as I understand, with a few things that are outstanding to be answered.
And that's kind of my point.
Right.
Yeah.
I do not believe that Mr. Kemp would say we've been dilatory.
There's just one expert deposition that hasn't been scheduled, but he's correct. Every single one of them is scheduled between now and June 7th.
And if there's a discovery cutoff and everyone agrees to go beyond the discovery cutoff, I'm not going to get in the way.
Okay.
Right? I'm not. And just as important, too, from a consideration perspective, if everyone's been diligent in the prosecution and defense of their case, you need one more deposition.
I get it.
Right?
Understood. We'll talk.
Yeah, you talk.
Okay.
So temper your discussions with knowing what my attitude is on that.
I'll get those orders up to you as soon as I can.
Okay.
I'll pass them by Mr. Kemp.
Oh, did we give you the status check date?
I did. Does that June 7th, does that work for everyone?
It's tough because we have depositions on that day. Honestly, if I were doing it, I'd do it on June 10th if that's a date that's available.
June 10th is a
June 10th
Saturday.
is a Saturday.
What's the next day of this court that they're in court?
I think we ought to stick with June 7th, Your Honor, because I don't have my deposition scheduled. We send out a schedule
We
every
have three
night.
on that day.
Yeah.
That's what I'm
Three on
worried
that
about.
day.
Yeah, I'm very concerned that we have you have two for sure. I know, and I've got
We could do the following week, which is June 14th at 9 a.m.
That kind of kicks us too close to.
Yeah, we're going down because that actually wanted it a week. We're getting 3 weeks now.
We could set
How
a
about the
special
day
session
after?
on a Friday. We don't
Can we do it on the 8th, perhaps?
it might be better.
Or
8th?
8th and the
I
9th?
have my calendar right here.
What do we
Let me
have
just
on
make
the
sure.
It's just a civil.
We can do it on the 8th.
Yeah, let's do it.
Just so everybody knows, June 8th is the deposition in Houston, Texas.
Yeah.
Are you going to be fishing? Good for you. How about maybe 1:30 in the afternoon on the 8th?
That's fine.
Yeah, that would work. 8th at 1:30.
Yeah, that way you don't have to sit. You only have one matter set, one session. That's this case.
Okay. Yeah, but, if
And if anyone's out of town, they're more than welcome. They can appear telephonically, of course.
and there'll be something issued from this court, or do I need to put that into an order?
We won't put it in the order. Status check date.
Excuse me, this is Elizabeth Lowell. It looks like we have depositions scheduled on that day until 2. I don't know if they'll go that long. But,
Who's the deposition that day?
Dr. Babcock.
Dr. Babcock and Dr.
Yeah, I think he'll be number 2.
So plan to say that deposition date, they'll be done by 2.
The real water 30B6 depositions that day too.
Yeah, you guys are busy.
Until 2.
Is 1:30 something that can be moved to 2:30 or 3?
Absolutely.
Let's do that.
You want it at 3:00?
Yes.
That's what we'll do because we need to keep the case moving forward.
8th and 2 at 3:00. I'll put that in the order.
Thank you, sir. All right.
Thank you.
All right, and we'll have more clarity hopefully by then as far as expert availability and all those things.
Yes, sir. Yeah.
Okay.
Thank you very much.
Enjoy your day, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.